Yo, you know who it is. NBPA Agent Mark Harris, aka Mike signed another one. I'm the CEO and founder of the Prototype Sports Agency, and I'm also a Texas real estate agent / investor. Before we dive into any content, I want to take the time to thank you for tuning into the channel and rocking with me. If you haven't already, go ahead and hit that like and subscribe button. That way, you'll always be first to get the drop when any content is posted to the channel. Now today, I'm going to be giving y'all the rundown on Rich Paul and Klutch Sports getting hit with a lawsuit over fees that allegedly were never paid to one of their agents. Now this is a touchy subject for me, being an NFL agent myself. The business consists of a lot of joint representation with agents having to work together to sign and retain players. In most of these cases, you have one agent or agency that forms a relationship with the player, and then another agent or agency that simply has more resources and can help put the player in the best position as they go through the pre-draft process. But that's only one scenario. It's a lot of moving parts that go on behind the scenes, and in a lot of cases, it's not as simple as signing a client to a multi-million-dollar contract and receiving a full 3% commission on the advertised value of that contract that you see on ESPN. In fact, there's very few instances where everything plays out to perfection. But let's get into it. On Tuesday, November 5th, a federal judge in Ohio blocked a petition Rich Paul and Klutch Sports filed to avoid litigation and settle a dispute through arbitration with NBA Agent Mark Termini. Now the dispute stemmed over payments for $1.4 billion in contracts that Termini and Rich Paul negotiated on behalf of LeBron James, Draymond Green, and other NBA players. Now, although agents are subject to arbitration provisions found in NBPA regulations, U.S. District Judge Patricia Ann Gargan determined that Termini's contract with Klutch does not contain an arbitration clause, and that the nature of Termini's contract don't fall within the substantive scope of claims subject to arbitration. Now, while Gargan supported Klutch in rejecting Termini's accounting claim, she rejected Klutch's move to dismiss Termini's breach of contract claim. So what does this leave both parties? Outside of a settlement or other filings, Termini's complaint is still pending and may soon be subject to pre-trial discovery. Pretty much going to court. What this implies is that NBA players just might be asked to take the stand, testify under oath, where they could be asked to potentially talk about text messages, emails, DMs, all that stuff that might make the picture more clear on whether Paul or Termini was the one that performed the majority of the work. Now the heart of the dispute revolves around Termini's claim that he was the one in charge of negotiating high-paying Klutch player contracts in the 2010s, while the more well-known Paul claimed credit and received public recognition instead. Now, additionally, Termini claims that Klutch made the decision to shortchange him on the bread, working around him and hiring third parties to do some of the work that he was contracted to do. Now, most of us know how this story played out with Rich Paul and LeBron James randomly meeting at the airport prior to LeBron being drafted. They kicked it out right away, and then a few years later, Klutch Sports was born, and LeBron gave Rich the opportunity to represent him as his agent. Now, things were a lot different back then with sports agents. The rules and regulations with sports agents, collective bargaining agreements for each sport, and most importantly, black agents carving out their own lane. Although LeBron gave him his start, Rich didn't get his real breakthrough in terms of success with other clients until 2014, when he successfully negotiated Eric Bledsoe's 5-year, $70 million deal after advising Bledsoe to hold out on signing a $28 million extension 1 year prior. You can probably get an idea of how we got where we are today, with Paul seemingly cutting out middleman. However, Termini ain't just asking for Klutch to throw him a few dollars to straighten the situation out. He's asking for $4.9 million in unpaid fees and other alleged harms. Now, there's always two sides to every story. Klutch has their own version while denying any wrongdoing. Now, Klutch's stance in relation to Gargan's order is that since NBA players are bound by obligatory arbitration clauses in NBPA bylaws, they should be able to handle this outside of court. Now, according to those rules, An agent who holds an NBPA certification enters into a contractual commitment to arbitrate disputes rather than pursue legal action. Now, some of you might remember back in 2022 when Klutch actually had one of these situations work in their favor, as a federal judge in Texas dismissed a case filed by Noel over what Noel would consider bad contract advice from Rich Paul. Now, that case was sent to arbitration since the NBPA collective bargaining agreement already contains language and measures to govern these type of matters. Goggins' order, however, concluded that this case is not going to arbitration. She said it doesn't fall within the scope of NBPA arbitration provisions. There's 3 types of disputes where arbitration would actually be considered appropriate. Number 1, the NBPA denies an application of a prospective agent. Number 2, there's a contract dispute between an agent and a player. Or number 3, there's a disagreement between 2 or more agents over fees and commissions owed when they have a joint representation agreement. Now, scenario 3 will be most relevant to the situation between Paul and Termini, except the fact that their dispute doesn't technically pertain to fees or commissions owed from any individual player contract. Goggins instead viewed it as a matter that concerns fees allegedly owed by Klutch to Termini from the contract Termini signed to perform services for Klutch. Now, unfortunately for Paul and Klutch Sports, this rules out mandatory arbitration, makes it very likely that the dispute will end up playing out in court. The judge also refused to dismiss the breach of contract claim, citing that it could be plausible. Now, Termini claims that there was an exclusivity clause in the contract with Klutch that was violated as Klutch began recruiting new agents to bring on board. On top of that, the judge highlighted Termini's claim that Klutch allegedly sandbagged contracts in 2020 until those new agents were officially on board, allowing Klutch to avoid paying Termini the fees outlined in their contract, while the new agents were put into a position to capitalize on Klutch's star power and brand recognition. At this point, things could get really ugly. It certainly seems to be headed for litigation, and who knows what might come out once they start calling both parties and any players get involved and have to go take the stand and testify. Pretty sure that some details that neither side really wants to be aired out, so we just might see Klutch give in and agree to a settlement to put all this to bed and move on. What are y'all thoughts on the situation? Should Rich Paul and Klutch come up off the bag, keep moving forward before the situation gets ugly, or should they let it play out in court in an effort to protect their image and credibility, which will be critical if they want to remain one of the top power players in the sports agency pyramid? Let me know in the comments. Well, that's all I got for you guys today. Stay tuned to the channel and look out for more content coming your way soon. Peace.